Now, we all know how Trump likes to get his way, and this latest setback is clearly not sitting well with him. Witnesses report that after his appeal got rejected by the court, the former president stormed outside the courts, muttering under his breath about rigged courts and deep state conspiracies.
I would say, in listening to the charges from the judge, who's, as you know, very conflicted and corrupt, because of the confliction, very, very corrupt. Mother Teresa could not beat these charges. These charges are rigged. The whole thing is rigged. The whole country's a mess between the borders and fake elections and...
But the real showstopper came when Trump grabbed a stack of papers from his desk and flung them into the air, scattering them across the room. Aides say he then proceeded to give the desk a few more good whacks with his fist, as if trying to intimidate it into overturning the appellate court's decision. Maybe that's not exactly how it happened, but we all know how the fault father is capable of reacting, don't we? Stay tuned, folks, because I have a feeling there are plenty more entertaining outbursts to come from the former president as this trial continues to unfold. Isn't it stunning how the criminal trial against former President Donald Trump has taken a shocking twist? Just days before the highly anticipated closing arguments, a New York appellate court has rejected Donald Trump's bid to force the recusal of Judge Juan Merchan from his criminal case. Trump claimed that Judge Merchan had overstepped his authority and displayed bias, but the court found no merit in these claims. The ruling means that Judge Merchan will continue to preside over the case, a significant blow to Trump's legal strategy. This decision comes even as jury instructions are expected at any moment, with closing arguments just a few days away. Neil Katyal, former U.S. Acting Solicitor General, talks with Alex Wagner about the state of the trial and expectations going into the coming week.
And joining us now from outside the Supreme Court is former acting U.S. Solicitor General and MSNBC legal analyst Neil Katyal.
Who doesn't commit crimes, which isn't a hard thing to do. We've had over 40 of them without any problem. Supreme Court's never said any of those 40 have absolute immunity. So this is actually a really easy case. I'm going to go walk in there and listen to it. Oral argument is supposed to be slated for an hour. I suspect it'll be a bit longer than that. But at the end of the day, the answer to this question is really, really painfully easy. And it's a little weird that we're all standing here waiting for the Supreme Court to decide a question that I think every serious constitutional scholar thinks the answer to is obvious.
The New York Appellate Court's decision was clear. There was no sufficient reason to remove Judge Juan Merchan from the case. Trump's lawyers had argued that the judge could not be impartial, but the appellate court upheld the initial ruling that Merchan had acted within his authority. One of Trump's main arguments for recusal was the employment of Judge Merchan's daughter, who works as a consultant for Democratic clients. Trump's legal team suggested that this connection compromised Merchan's impartiality. However, the appellate court ruled that this was not enough evidence to warrant the judge's recusal. They emphasized that familial connections do not automatically imply bias, particularly in the absence of direct involvement in the case. Another key point in Trump's legal strategy was his claim of presidential immunity, particularly concerning his social media posts. We all know how cranky some of these posts are. For instance, it says here, "Sleepy Eyes Chuck Todd is so happy with the fake voter tabulation process that he can't even get the words out straight. Sad to watch." And by Sleepy Eyes, he means no other person than Joe Biden.
Hey, Wick, good morning to you. And former President Donald Trump is clearly frustrated heading into this pivotal week in that hush money case. The former president spent the Memorial Day weekend lashing out at various judges overseeing the criminal and civil trials against him. Just hours after posting to social media to honor our fallen veterans on Memorial Day, the former president quickly turned to attacking the, quote, human scum, claiming that they are destroying.
Judge Merchan had previously denied this argument, and the appellate court upheld this decision. The ruling reaffirms that former presidents are not above the law and can be held accountable for their actions, including those taken on social media platforms. Trump also sought to change the venue of the trial, arguing that pre-trial publicity in New York was too intense for a fair trial.
I don't know how much the Supreme Court's going to be influenced by the fact that this is a kangaroo trial. Obviously, if the Las Vegas odds makers are betting on any case against Donald Trump in the District of Columbia, the odds would be infinity to zero. Nobody is going to place a bet on an acquittal in front of this judge and this jury in the District of Columbia, where 90-something% of the people voted against Trump.
Trump's legal team pointed to the George Floyd case, where a change of venue was considered due to extensive media coverage. However, the court found no compelling evidence that another venue would offer less publicity or more impartial jurors. The decision highlighted the difficulty of finding a location free from pre-trial publicity, given the high-profile nature of the case. Changing the venue of a trial is no simple task. It requires a demonstration that the pre-trial publicity in the current location is so pervasive that finding an impartial jury is impossible. Trump's legal team failed to show that any other location would have less pre-trial publicity. This decision means the trial will continue in New York, adding another level of difficulty for Trump's defense. A major point of contention in the trial is the level of criminal intent, or mens rea, required for conviction. Trump's defense argues that a specific intent to violate campaign finance laws is necessary. They claim that Trump did not have this intent and therefore should not be convicted. On the other hand, the prosecution seeks a more lenient approach, suggesting that a broader interpretation of intent should apply.
On the witness stand, Daniels provided details that prosecutors today said were cringeworthy but ring true, from what Trump was wearing to the contents of his toiletry bag. Trump's lawyers called Daniels' testimony pure embarrassment, meant to inflame the jury. The defense arguing Daniels was out to extort Trump, saying she saw a time to strike.
The big, shocking thing left out of this defense is absolutely zero explanation for the $130,000 entry on that piece of paper that calculates how much Michael Cohen will be paid, which the defense is insisting is not a payback.
Trump's defense team is also pushing for the court to require proof of specific intent to violate campaign finance laws. They argue that without clear evidence that Trump intended to break these laws, he cannot be convicted. This argument is central to their strategy, as it aims to raise the bar for the prosecution's burden of proof. As the trial moves to its final stages, jury instructions will play a critical role. The judge will provide detailed guidelines on the legal standards and the elements needed for a conviction. These instructions will help the jury understand the complexities of the law and apply them to the facts of the case. And it's quite likely that the clarity and precision of these instructions could significantly impact the jury's deliberations. Trump has chosen not to testify in his defense, a decision likely influenced by the fear of perjury.
Allegedly well into his presidency. And tonight, what did Donald Trump mean when he said late today, "I cannot testify"? Aaron Katersky at the courthouse.
Trump has repeatedly said he would testify in his own defense, but today, on his way out of court, he made this false claim.
Well, I'm not allowed to testify. I'm under a gag order. I guess. I can't even testify on that.
The gag order does not prevent Trump from testifying, as he has said on at least 3 different occasions he would. Every criminal defendant, David, has the right to testify in his or her own defense. That includes Donald Trump.
Taking the stand could expose him to rigorous cross-examination and the risk of making statements that could be used against him. But by not testifying, Trump avoids these risks, although the jury will be instructed not to infer any negative conclusions from his silence. Trump's refusal to testify is based on the belief that there is no strong case against him. He and his legal team argue that taking the stand would only open him up to potential pitfalls without providing significant benefits. This decision is a calculated risk, balancing the potential advantages of presenting his side of the story against the dangers of cross-examination. However, here's where the real issue comes up. There is speculation that Trump's attorneys advised him against testifying to minimize risks. It's safe for legal experts to often counsel clients to avoid testifying if the potential for self-incrimination or damaging admissions outweighs the benefits. But in Trump's case, avoiding the stand may mean something else that the court isn't aware of. And it seems the jury is handicapped in this circumstance, as they will be explicitly instructed that they cannot draw any negative inferences from Trump's decision not to testify. Also, let's consider the fact that a significant part of the defense strategy revolves around attacking the credibility of Michael Cohen, Trump's former lawyer. The defense argues that the case is fundamentally about Cohen's reliability, suggesting that his history of lying undermines his testimony. They aim to create reasonable doubt by casting Cohen as an untrustworthy witness. But here's another twist that makes this case all the more interesting. The prosecution has said that it's not solely relying on Michael Cohen's testimony. They have presented corroborating documentary evidence to support their case against Trump. This evidence includes financial records, communications, and other documents that they argue clearly show Trump's involvement and intent. The prosecution's strategy is to build a robust case that does not hinge on any single witness. Hence, for Trump to be convicted, the jury must reach a unanimous decision. This requirement underscores the importance of each juror's agreement on the verdict. If the jury cannot reach a unanimous decision, it could result in a mistrial, adding another layer of complexity to the proceedings. On the other flip of the coin, if Trump is not convicted, there is a possibility of a retrial. The defense's tactics, particularly regarding their handling of witnesses like Cohen and their focus on specific legal arguments, could influence whether the prosecution decides to pursue another trial. And all Americans patiently await the outcome of this trial, which we believe will have significant implications for any future legal actions against Trump. Let us know your thoughts and opinions in the comments below. And don't forget to like, subscribe, and turn on your notification settings.